So now we're going to turn to the forms, and we're going to start with Form A, which is the application for appointment as guardian, co-guardian advocate. So I want to point out about the style of the case. The case style is that top part in the circuit court for the 13th Judicial Circuit of Hillsborough County, probate, guardian, mental health. You're going to see in re guardian advocacy of. On that line, and on every form you fill out, you're going to put your child's name, okay, at the top there. So that is the person with the developmental disability. All right? There's no case number or division when you file some of these forms because you haven't filed them yet, so one hasn't been assigned. So, but you do want to make sure, because there's that case style is on every form that you're filing, you need to make sure your child's name is on there. All right? The first paragraph that's on there where there's a blank line, your child's name is going to go in there. So the undersigned submits this application for appointment as guardian, co-guardian advocate of the child, the person with a developmental disability. After that, everything's about you. Okay? I can't say it any clearer. Everything's about you. Your name, social, date of birth, residence, all of that. If you are currently serving as a guardian for anyone else, in question number 12, you'd answer that question. If you are not, then don't just leave it blank. Put something so they know that you read the question. So I'd put N/A for not applicable. Do you have any physical disabilities? Pretty simple, yes or no. What are they if you do? It's not going to prevent you from being able to serve unless it's a severe mental health type issue that obviously you can't serve on behalf of your child. But it's just, you need to let the court know how is this going to affect your ability to serve, if any. Have you ever been treated for any conditions? And then it lists the types of conditions, and then you state what it is, and then you state, what your treatment has been for that condition. And then the next several questions, 16 through 20, if you can't answer no on those questions, then you're probably not going to be allowed to serve as guardian because that's your criminal history. So you have to have been convicted of a felony. So if it's a misdemeanor, then you're going to have to state what that is. You're going to have to list all that and let the court know. And let me tell you something, don't leave it out, even if it's a misdemeanor, because they do a background check on you, they're going to find it. So make sure you state it in the application. You can explain it. It's not, if it's not a felony, it shouldn't prevent you. In most cases, it should not prevent you from being able to serve. But you need to state it. The judge may ask you questions about it, but it should not prevent you from being able to serve. 21 is a question about bonding. Have you ever held a position that required bonding? If you don't know what that is, then you probably haven't held such a position. So you put no, because you have to fill out an application and everything to be bonded. So just put no. Have you ever served in the past as a guardian of a person or person's property? Again, it's yes or no. Ever been held in contempt of court or removed? Yes or no. Ever filed for bankruptcy? Again, these are yes or no questions. Just answer them truthfully. If there's a yes, especially if it's some sort of a court proceeding, please put the truth. Don't lie, because they're going to find it, because they're going to do a background check on you. Have you ever convicted or found guilty, pled no contest to an offense prohibited under Florida Statute 435.04? That's our abuse statute. So have you ever been convicted of any type of abuse on a disabled individual or a senior or anything like that? And then 26, what's your relationship to this person? You're their parent, you're their sibling, how are you related to them? You're a caretaker. 27, I'm only going over these next ones because people get confused by them. Is the applicant or the applicant's business corporation, business entity or other business entity a creditor of or providing substantial professional, personal, or business services to the person with a developmental disability? If you are the parent or a loved one who is trying to be the guardian, then the question of that is most likely no. This is if there's somebody who's working for a company of some sort that needs to be serving as guardian.
But through the waiver, I do provide services to my son, the CDC waiver.
Right.
I pay for that, so
Then you would list what that is. Yes. When in doubt, give them, when in doubt, explain it. But yes.
It's like he's employing you through the CDC waiver.
Right. If there's a waiver that your child is on that you are getting paid to take care of them, then you could state that. You could state that in here. Is the applicant employed by a person, agency, government, corporation, or other business providing professional, personal, or business services? Are you a health care provider for the person with a developmental disability? Well, you're their parent, but you're not a doctor, you're not a nurse, you're not their health care provider per se. Number 30, your education history. Put as much as you have, high school, any college, just put, what you have there. The name and the address, what if it's high school, did you get a diploma or what grade did you stop? If it's college, what kind of degree? Is it a 2-year degree? Is it, an AA, a BA? And then the date that you graduated. Your employment experience for the past 10 years. If you're retired, put retired for the last 10 years. If you are, working someplace, just put what you have going on. If you're a stay-at-home parent, put that. I don't work outside of the home. I work my butt off inside the home. Don't put that, but just put you're retired or you're a stay-at-home parent or whatever your work is. Have you ever been discharged from employment? Have you ever been fired or let go? Yes, and just put the reason why. Are you a member of the armed forces? You put that information. Personal references. So question number 34. Fill this in because people leave it blank all the time. Again, this is part of their way of checking up on your background. So you need the name, the address, and phone number of 3 people who have known you for at least 5 years who are not relatives or your spouse. So who do you work with? Who are your neighbors? Unfortunately, some of us don't know our neighbors at all because I had somebody who said, well, I don't know anybody who lives around me and I don't work, so... But there's got to be somebody that you know that you can list. 3 people that have known you at least 5 years, okay? And put all of their information. Do you have any special education? So number 35, any special education qualifications that uniquely qualify you to be appointed their guardian? This one always cracks me up because usually parents will put, yes, I'm their parent. I've been taking care of them for the last 18 years. And if you want to put that, you can put that. But if you have anything uniquely, you've got an RN background or you've got a social worker background or anything like that, they want to know that. So go ahead and put that information in there. And have you received any instruction or training, number 36, which covers the legal duties and responsibilities of your rights as your responsibilities as a guardian, the rights of the ward, etc. If you haven't served as a guardian, then you don't have that training because there's a specific course that you take. If you are a court-appointed guardian, there's a course you have to take to everything we're kind of talking about with regards to the plans and everything. They go over all of that. So you probably haven't, taken that kind of course, so you can answer that. You can answer that no. And that's it. You're going to sign it. And you're going to fill out the bottom of this completely. Print your name, your address, phone number, email address. You're putting that on every pleading that you are signing. Okay? And if you don't do it, they're going to kick it back to you and say, this wasn't done correctly because they want it on everything. All right. So, and that application is for whoever's serving as guardian advocate. Again, so if it's 2 people, each person has to fill one out, right? Okay, the next form is the application for determination of civil indigent status. I put a copy of it in the forms, but on the website, if you go on Hillsborough County Clerk's website, it's not in the forms because it's a separate form. I'm not even sure where it's at. It's a separate form. I think it's around where the forms are that you have to use, but it's not going to be in there. So either use this one, or I would encourage you to check out the form. And probably if you Google application for determination of civil indigent status, Hillsborough County, the form will come up. I love Google. And it's sad how we rely on that for our research. But if you Google that, the form will come up. And I would use that form because they may change it from time to time, and the form in here could be outdated. So you want to make sure you use the form that they have. But let's go ahead and go through this. So with the case style, the first line is your name. The line that is above, in the interest of guardian advocacy of. The first line is the person who's filling it out. Okay, so remember, each guardian has to fill one out. So the guardian's name, in the interest of the guardian advocacy of, and then that line is the ward's name. And then the rest of this, questions 1 through 6, is about your child. So I have, in most cases, it's going to be 0 dependents because they don't have children. Although we've done guardian advocacies for much older people who might have a child, but I have 0 dependents. Are you married? No. Number 2, I have a net income of, so that's only if they have a job, like let's say they work at Publix or some, work at the movie theater or something like that. They have a little part-time job where they're making a little bit of money. That's where you would put that information, okay? And how do they get it? Do they get it weekly, bi-weekly, semi-monthly? So number 3, if the second job doesn't apply, unemployment compensation, all these other things, you want to answer no. So you want to answer yes or no for each one of these. Number 4, I have other assets. So here's where you're going to list. Do they have a bank account? If they do, how much is in it? Do they have any CDs? Do they own anything like a boat or a vehicle or a homestead? Do they have savings accounts, stocks or bonds, non-homestead property? You're going to list all of that here. If it's no for everything, then you're going to circle no for each one. Next, under 4, it says, I do or do not expect to receive more assets in the near future. So typically that's going to be do not, but if there's some sort of a lawsuit and there's a settlement that could be coming down the road, you need to list that there is the potential for that. Number 5, I have total liabilities and debts. Again, generally this is going to be 0 across the board, and you want to write that for all of those things. There's no, $0, no, because there's no vehicle, there's no home. But if there is, you have to look through each and every one of these, and if it is applicable, you need to write what it is. Okay? Number 6, I have a private lawyer in this case. Generally, the answer to that's going to be no, because they have a court-appointed attorney that's representing them. All right? And then you are going to put your date of birth, your driver's license and address, and your phone number, and then sign it at the bottom. Form C is the waiver and consent to appointment of guardian advocate. At the top, the style of the case, you're going to put in re guardian advocacy of, your child's name goes on that line. If the parent, the other parent who's not serving, is signing this waiver and consent, then that's whose name goes in here. So the undersigned, the parent that is not going to serve, whatever their name is, and then you need to state what their address is, who has an interest in the above guardian advocacy as the, what are you, the brother, sister, parent, child. Brothers and sisters don't generally come into play if both parents are still alive. We only list adult siblings if both parents are gone. As the parent, usually a parent, and then the name of the child goes there. The blank line of the person with a developmental disability. If the parents are both serving, then you don't need to worry about this form. Okay, and then again, signature, print name, address, phone number, emails. All right, Form D is the petition. So we're going to go through this. Okay, so again at the top, in re guardian advocacy of, and the adult disabled child's name is going to go there, right? So petitioners. So if you have more than one petitioner, pick who's the petitioner and pick who's the co-petitioner and, stick with that. So because there's several places where it says petitioner's information, co-petitioner's information. So mom's the petitioner, dad's the co-petitioner, and keep consistent with that throughout this. If it's just you and there is no co-petitioner, just make sure again that you write NA, N/A, through the lines so that they are aware that you read that question and there's nobody serving in that capacity, okay? The very first line, where above number 1, where it says petitioners blank allege, you're going to put your names in there. So, by the way, the petition it's only one petition. Everybody's information is going on the petition, right? So We don't need two petitions. We just need one petition. So both names. So if it's mom and dad, it's petitioners, comma, mom and dad, comma, allege. If it's one person, whoever's name is in there, alleges. So number one, petitioner, and then mom's information. So mom's name, residences, mailing addresses. Now, it may be the same thing, but this is their form. This is how the court wants it. So put it in twice. My residence address is, 123 Main Street. My mailing address is 123 Main Street. Okay? Number two, so that's where the co-petitioner. So number two, co-guardian advocate, petitioner's name, and then residence and mailing address. All right? So that dad's information would go there. I'm going to use mom and dad as the names. All right? Number three, petitioner's date of birth. So we're back to mom. What's her date of birth? What's her age? The name of the child, and then the person with a developmental disability is, and then you're stating who you are to that person. Okay? So that's the information in that order that goes in that line. Number four, now we're back to dad, the co-guardian. Same thing, dad's date of birth, his age, and then his relationship to the ward is father. Number five, so that's the first line to number five is the name of the ward, the person with the disability. So this is all about the ward, who was born on, so that person's date of birth, how old are they, and there's their social security number. Now your social security number is given in your application, so the only social in the petition is the ward's. So on line 6, you're going to put the non-petitioning parent, and if there are any adult siblings, the name of those adult siblings. All right, so number 7. Number 7 is asking what's their disability. Check which one it is. If it's not any of these, you shouldn't be here and filing this. Okay? And then you're going to put the grade level that the adult disabled child functions at. So typically, you've got an IEP, it may state it in there. Most times, somewhere in the medical records, the doctors put, at what age level are they functioning at. And then if you know that age level, then you can pick what the grade is, right? Number 8. So the petitioner believes that a guardian advocate is necessary because the ward lacks the decision-making ability to make informed decision about the ward's own person, specifically the following rights. This is, and again, depending on what county you're in, they may not have all of these. So for Hillsborough County, what you need to remember is these are all the rights that can be taken away under a full-blown guardianship. Okay? For guardian advocacy over the person, the only rights that you are going to be able to have is in Hillsborough, they'll allow you to personally apply for and manage government benefits because anybody can be a representative payee of the child for SSI benefits. And then to determine residency, to consent to medical and mental health treatment, to make decisions about their social environment, and to travel without assistance or supervision. Those are the ones that they will give you as guardian over the person, and those are the ones that you should be checking off if you are filing on your own. If you're filing guardian over the person and property, you're using an attorney, we'll handle it. But for your purposes, those are the only ones that you're wanting to have because you're only filing for guardian over the person. Number 9, again, they want to know what your relationship is to the ward. So that blank line in there, you're going to put who you are again. Parent, brother, sister, whatever. But basically, so this petition is telling the court some things, right? It's telling the court about your child, but then it's also telling the court, I am willing to act as the guardian because I am the ward's parent or whoever you are. Number 10, you're stating that you're letting the court know the child, the adult disabled child, is not able to understand the concept of legal representation and cannot afford an attorney for this proceeding. So that kind of goes back to that indigency affidavit that we're filing. Number 11, in accordance with the probate rule 5.649, petitioner has knowledge or information and belief that the ward has or has not created an advance directive or durable power of attorney. So you're going to circle one. Has the child previously signed a durable power of attorney and a healthcare surrogate designation? If they have not, then you're going to circle has not. I would circle it to make it clear. If they have, then you're going to circle that one. Okay? And then when you come to court, if they have signed something, the court's going to want to know, well, how come that's not good enough? What's going on that the power of attorney and the healthcare surrogate designation are not good enough? They're going to want to know that. Number 12, again, you're telling the court the child is indigent, they don't have any assets, no income other than public assistance, which is considered SSI benefits, and we're requesting the court waive all the costs in this case. And then, again, that refers back to that affidavit of indigency that you're going to file. Number 13, petitioner requests that the court set a hearing to inquire into the capacity of the ward and determine it is appropriate to do so. If they determine, enter an order appointing, your name goes in that first line, so whoever the guardian wants to be, your names, if it's co-guardians, right? And then enter those people as guardian advocates for, and that second line is the ward's name, the adult disabled child's name. Number 14, paragraph 14, you are telling the court that you have filed your application for guardian advocate, and you submit to a criminal background check and a records check pursuant to, there's an administrative order in Hillsborough County that the court requires this be done. Okay, and you're saying, yes, go ahead and do that. And number 15, the initial plan and the first annual plan, once those have been filed, you're requesting that the court allow you to file a simplified plan after that without having to file a doctor's statement. Because with a regular guardianship, I just state that's not the legal technical term, so for anybody out there in video land who wants to criticize my words. For a regular guardianship, you have to file a physician statement every year because you have to tell the court, yes, this person is still disabled and has not recovered any ability to get any rights back. Well, with the developmental disabilities, they know they're never going to recover from the type of disability that they have in all likelihood. There may be some instances, you know, depending on, because it could be for autism and they may be higher on the spectrum and they may at some point be able to petition to get some of their rights back. But generally in most instances they're not, so that's why the court has waived you having to file a physician statement and let you have the simplified plan. Okay, you are signing this under penalty of perjury. So you are stating everything in here is true to the best of my knowledge, and then you're signing this. So everybody who wants to be a guardian advocate must sign this. So again, the first signature block should be the petitioner, the second signature block should be the co-petitioner, so we're keeping in order. Okay? And fill it in completely, because again, they want those email addresses, phone numbers. If you don't have an email address, create one through Gmail or Yahoo or whoever you need to create one for, because the court will not allow you to represent yourself if you don't have an email address that they can contact you through. You will not get this through because they want to have a way to contact you, and for whatever reason they're stuck on emails. They need to have that email. And then the certificate of service at the bottom, if you have no next of kin and you have no parent that you're serving, you only need to put in the ward's information on here. If you have next of kin or a parent, you're going to include them. So I, the guardian. Okay, so your name, and it can be either one of you. It doesn't, if there's two of you, one of you only needs to sign this. So I, the guardian, do hereby certify a true and correct copy of the attached petition has been furnished by, and then put what kind of mail. Did you send it certified? If it's somebody who's not signing the waiver, you do need to send it by certified mail. Whatever date you sent it to, and then you're going to put the ward's name and address. And then again, the parent who's not signing the consent, the next of kin, name and address. Okay, Form E is the report of the attending physician. This is just needed if you don't have a doctor's report that says what the diagnosis is from an MD. Form F is the oath of the guardian and co-guardian advocate, designation of resident agent, and acceptance. So each guardian must fill this form out, okay? So this is all about you. I, whatever your name is, state under oath that I will perform the duties of guardian advocate of the person of. So number 1 is the ward's name or your child. Number 2 is your address. So again, your residence and your post office address. And that has to be, it's done in front of a notary. So don't sign it until you get in front of a notary, because you have to sign it in front of the notary. Okay? Form G, the notice of confidential information within court filing. So this document tells the court, we've got some information in the petition and our application that needs to be redacted. Okay? So I'm going to tell you exactly what to put based on the forms, that we have today. Now, caveat, the forms could get amended at some point in the future, so these numbers could change, the paragraph numbers could change, but right now this is what they are. So you're going to check mark, where you can see where it's a check mark. So you're going to check mark the first one, petition for appointment of guardian, co-guardian, and it's page 1, paragraph 5. Because that's got the child's social security number, okay? You're going to check the next one, and if you're co-guardians, it's going to be the petitioner first for the first one, and then you're going to check the one after that for the co-petitioner. So application of who's the petitioner, mom or dad, right? And then page 1, paragraph 2, because that tells them your social security numbers in that application. And then the next one is for the co-guardian, so you'll check that one if you have a co-guardian. An application of dad, or whatever his name is, pages, again, 1, paragraph 2, because it's the same application, and you're telling them social security numbers there. You're going to check the confidential, it says psychological report, it's whatever the doctor's report is. So you're going to check that one, because the entire report is confidential. And then you're going to check the next one, credit reports of, and then you'll put in both names, if there's, or however many names, whoever's serving. If there's a deceased parent, then you're going to check that one, because you're going to be filing the death certificate of that parent too. All right, but if there isn't one, you can leave that blank. And then on the lines, that paragraph that says indicate the applicable confidentiality provision, you're going to put social security numbers, credit report, financial information, doctor's report. Because you're letting them know what it is that's in those paragraphs that has to be redacted, so they know what to look for. Only one of these gets filled out and signed by whoever, but you're telling them everybody's information, what's in everything that you're filing. The next form, Form H, is the notice of the petition to appoint the guardian advocate. So this is, you're notifying whoever the relevant parties are that you served the petition with that there's going to be a hearing, and this is the date and time of the hearing and who we're in front of. And go back up to the case style. Don't forget, in Ray Guardian Advocacy of, put the child's name, okay? And then where it says to, subject's name is the child, the ward, and address, and then whoever the next of kin are. The first line in that in number 1 is the ward's name. The next line is the name of the magistrate that you're in front of, and you're going to know that because when you file your paperwork, there's going to be an order that you get that tells you who the relevant parties are, the magistrate judge and the court-appointed attorney. So you're telling them there's going to be a hearing in front of magistrate, whichever one it is, and that'll also have all their address information and what courtroom they're in. So you'll fill in the courtroom, hearing room, and then the date and the time of the hearing date. You'll fill that in number 1. Number 2, the ward's name goes in both of those lines. So we're telling everybody the reason for the hearing. Number 3, this is because this notice does go to the person with the developmental disability, giving them who the court-appointed attorney information is. So you're going to put the name, it kind of breaks up. So number 3 on the next page, there's a space to fill in the name of the court-appointed attorney, their address, phone number, email. You'll have that information from the order. And then you fill in the certificate of service and state what date that the notice was read to or served on the ward. All right, so skip to J. All right, so J, so after you've scheduled the hearing, you're about to go to the hearing. Remember we said you're going to call the judge's judicial assistant and you are going to ask them, a couple days before the hearing, just call to confirm. This is the date and time I have scheduled for the hearing. Just want to make sure everything's in order. Do you need me to bring the order, the letters? What do you need me to bring? And they'll tell you, okay? So the order appointing the guardian advocate, the judge, not the magistrate is going to file a report and recommendations to the judge. The actual judge, the Hillsborough County judge, will sign this order, but you are filling it out for them to sign, okay? So again, at the top, now also I will point out, by this time you're going to have a case number, so you're going to want to make sure you put your case number, and it'll tell you case number and division that you're in, okay? So make sure you fill that in re guardian advocacy of the developmentally disabled adult's name, okay? Number 1. So the first paragraph, that first blank is your child's name, the adult disabled child's name. The second blank in paragraph number 1 is their disability. What is it? What's the diagnosis? Number 2, when the court signs this order, this is just stating that a hearing has been done, has been held, and they find that the child lacks the capacity to make certain decisions. Number 3, the ward's specific legal disability is, and again, you're going to state what the diagnosis is. And then number 4, you're just going to leave that alone, and then you just leave the rest of it blank. The judge will fill in the rest. All right? Form K, these are your letters of guardian advocacy. So Form K is your authority to act. This is what you're going to get a certified copy of after the judge signs off on everything. Okay? So just mark that off at the top. Be sure to order a certified copy. The certified copy, it's $1 per page and $2 for the certification. So this is 2 pages, so it's going to be $4 that you'll have to pay to the clerk right now. In 2019, they can change that, raise their fees. But that's how much you would pay to get a certified copy. All right? So again, at the top, we're going to fill in re guardian advocacy of, and then that line is the child's name, comma the ward, and then you're going to fill in the case number and the division. Whereas, you're going to put the guardian's name in the first paragraph, whereas mom and dad, you're going to put both names of both people. So if there's more than 2 of you, you're going to put write small. Have been appointed guardian, co-guardian of the person of, and then that second line is the child's name. And then the third paragraph, same thing, where it says, now therefore I, the undersized circuit judge, declare that guardian's name is that first blank line, and then the ward's name is the second blank line. You're going to leave the rest of that blank. The judge will fill that in. Okay? And then on the second page, that next blank line, the second to the last paragraph, that's the ward's name, the child's name. And then the rest of it you're going to leave blank. The judge will fill the rest of it in. All right, and then Form L and Form M are the plans. So again, the initial plan gets filed within 60 days after the judge has signed the letters. So whatever date is on those letters of guardianship, within those 60 days you need to file your initial plan. So the initial plan is Form L. So again, at the top, you're going to write the child's name, in re guardian advocacy of, and then the adult disabled child, and then case number and division. That first paragraph, the first blank line is your name or whoever's serving as guardian. So if there's more than one of you, all the guardians' names go in that first blank line. Guardian of the person of, the ward's name goes in the second blank line. Number 1, so this is the part that can kind of get confusing. So during the period beginning on that first date is the date the letters were signed. Okay? And I'm going to give you an example after I tell you what goes there. So during the period beginning, the date the letters were signed, that's the first date, and ending, that date will be the last day of the month of the next year. So let me give you an example. During the period beginning, and we're going to use an example, so during the period beginning March 1st, 2019, if that's the date that your letters were signed, and ending March 31st, 2020, which is the last day of the month that the letters were signed. And if you have a question about, if you're still not sure and you're a little confused, I would call the court-appointed attorney and ask them, can you help me out here and tell me what the dates are I'm supposed to put in here? They should be able to help you with that. All right? The rest of this just goes through, again, the medical, mental, personal, what are the services that they're getting? What doctors are they regularly visiting? What are the social services? Like, are they going to school? You know, are they in some sort of daycare or aftercare program? What's their best place for them to be living? At your house, why is that? Because I can take care of them. You just put what you need to put to explain to the court why that is. Are they receiving any, D is, what are their health and accident insurance, any type of benefits that they're receiving. So what's their health insurance? Are they getting SSI, put that they're on SSI and Medicaid? Or do they get Medicare benefits? Like what kind of benefits are they getting? What type of examinations will they be receiving in the future that you, and if you don't know the exact date, that's okay. You could just say, you know, my child typically goes to Dr. Smith in the summer. You know, whatever. You're just giving them an idea of what's coming. And that's it for the initial plan. The rest of it is, you can read through that. And again, it's things that you are signing under penalty of perjury that you're telling the court, yeah, I either have reviewed this or I haven't reviewed this, you know, with the ward. And then both, if there's more than one guardian, you will both sign off on it. And then you will, this is the only time you're going to serve the plan on the court-appointed attorney. You do not need to serve it on the ward, but you do need to give a copy of this plan to the court-appointed attorney. So you're going to mail it to them by regular mail. And you're going to put that in the certificate of service. So I, whoever the guardian is, am serving, have furnished, and again, it can be by regular mail on whatever date you mailed it to, and then you're going to put the court-appointed attorney's name and address, and then if there are next of kin, or if one of the parents is not serving, you'd serve it on that parent. And then only one of you needs to sign it. Okay? The annual Form M, the annual guardianship plan, I'm just going to go over the top part. The first line is the guardian's name. The second line is the ward's name. And then that paragraph underneath, it says the annual guardianship plan for the period beginning. Okay? So now think about those letters. The letters were signed on March 1st of 2019 and went through March 31st of 2020. So that first date there is going to be April 1st. So the first day of the month of that following year that the letters were signed. So in my example, April 1st, 2020, and then ending the last day of the month of the next year that the letters are signed. So that would be March 31st of 2021. The last day of the month the letters were signed. So we're going from one year to the next. So the initial plan covers the date the letters were signed until the following year, the end of that month, the date the letters were signed of the following year, right? The annual plan picks up on April 1st, so the first day of the month after those letters were signed, but then goes through the following year after that, because this is a prospective plan, so it's telling the court what you're doing for the next year, right? The annual plan is. So the last day of the month that the letters were signed for the next year. Okay, so let me say it again for my example. The initial plan covered March 1st, 2019 through March 31st, 2020. Then the annual plan that we have to file the following year is going to cover April 1st, 2020 to March 31st, 2021. Doesn't that sound weird to say that? But that's what it's going to cover, okay? And then again, you're just going to go through this and you're going to put where the child lived. If it's the same place, you're just going to list the same address. Just read the italics because that tells you what's expected, what they're looking for. Okay, it's a little bit more detailed. I will point out to you that number 5, that talks about attaching the report of the physician, you won't need to do that because that is going to be waived by the court. So in Hillsborough County, you don't need to do that if you're filing in Hillsborough County. So I would put in paragraph 5, just put waived by the court, because that will be in the order, and then that just lets whoever's reviewing the plan know. They'll check and they'll make sure that that's the case. All right, and then the rest you can just fill out in accordance with the information that they're asking for. Again, I will point out number 9, is the ward capable of having some or all of their rights restored? Typically that answer is no, but if there is something that you think they can start making those decisions on their own, you can write yes and explain what it is. Number 10, do you plan to seek restoration of any rights? If you answered no to 9, then you're going to be answering no to 10. If you answered yes, then you need to explain to the court why you're not going to be asking to restore that right that you answered yes to. And then number 11, the plan has or has not been reviewed with the ward. So, if they're capable of understanding it, you can go over it with them. If they're not, then you just say it has not been reviewed with them. Okay? And then again, you're signing under penalty of perjury, and you are, both of you are signing. If there's more than one guardian, you both, or however many, will be signing. And this does not have to be filed, this doesn't have to be served on anyone, it just has to be filed with the court. So the annual report is going to be filed within 90 days from the anniversary date of being appointed. So that anniversary date is the date on your letters of guardianship. And so it's that 90-day period from the date of the letters of guardianship after. So my advice is just file it as soon as possible, on that date. Make sure you set a reminder in your calendar. Have some way to remind yourself, because if you don't file it, they will issue an order to show cause, and then you'll have time to file it, and then it'll be fine. But if you're consistently late, they don't like that. So don't be late filing it. If you don't file it, that's not a good thing, because you'll lose your right to be guardian, and you'll have to go in front of the judge and answer why you're not filing this.
They don't send it to you?
They do not send it to you. They will send you an order approving the annual plan.
Okay.
And that order will, it will tell you when the next plan is due. It will usually, they stopped doing that for a while and now they're doing it again. So I can't guarantee you, because they could change how they do things. But in that order, you want to read it all the way through, because it will tell you you are now allowed to file a simplified plan, and the simplified plan is due between this date and this date. Okay. And then it's your job to, and they'll give you, I even think they send you a copy of the simplified plan. It's 2 pages, a blank one. But you can also go online and get it, and then it's your job to remember when to do it. They don't send you any more reminders. Well, I want to thank everybody for coming, and I just want to say to anybody who's watching the video, if you have questions, you can leave questions in the comments below, and we will try and answer those as we can. And I want to thank you again for watching, and I hope that this helps you guys with your families.
Thank you so much.
You're welcome.